I think it's not at all evident to the majority of the population that we wish to, we want to, we must reason about justice. And thus, arbitrariness is the complete antipathy of reason. I think school children should be taught from the earliest age. I have in my mind the picture of "Yes man, yes man, yes man" with Jim Carrey, where the children shout out "Arbitrary, arbitrary, arbitrary," in being able to discern when human beings are making decisions which are arbitrary, that really, as a matter of justice, are calling to a universal principle, but the person involved is paying too heavy attention to particulars and their particular judgment on those particulars.
This court does not arrive at its conclusion lightly. On one hand, Reuben Carter has submitted a document alleging racial prejudice, coercion of testimony, and withholding of evidence. On the other hand, Mr. Carter was tried twice by two different juries, and those convictions were subsequently upheld by the New Jersey State Supreme Court.
He's going to rule against us. Reuben's going to lose.
However, the extensive record clearly demonstrates to this court that Reuben Carter's conviction was predicated upon an appeal to racism rather than reason, and concealment rather than disclosure. To permit convictions to stand which have as their sole foundation appeals to racial prejudice is to commit a violation of the Constitution as heinous as the crimes for which the defendants were tried and convicted. I hereby order Reuben Carter released from prison henceforth from this day forth. This court is adjourned.
Well, I reject the finding of this working group. It's a group made up of lay people, not lawyers, and they are their conclusion is flawed in law.
At the highest levels of law, at the highest level of appeal in the legal system, the judiciary, you find knowledgeable people speaking about the law, speaking about principles, and when they overturn injustices, they're pointing to holes in the law or holes in the interpretations of the law that have been manifest. Very often, as in the Assange case, it's not necessarily a personal indictment of your decisions. There is a quote which says, I'll put it in the law bar, something like that, justice goes awry with men of zeal just trying to do the job, yeah. And in this sense, it's not personal.
Julian Assange is a fugitive from justice. He's hiding from justice in the Ecuadorian embassy. He can come out onto the pavement anytime he chooses. He's not being detained by us.
Now, the Conservative MP and Secretary for State does begin to draw personal criticism here. It's almost as if he hasn't read the judgment and the opinion. He can draw the judgment and the criticism of being superficial insofar as only recognizing imprisonment as being behind bars and that the state physically put them there. This is clearly a nonsense. For example, in the Myanmar lady who was imprisoned under house arrest, where she could freely leave as long as she left the country. Or when in the case of abductees or prisoners, where after a prolonged period of time they actually enjoy a freedom to leave, and for many years they simply don't. They don't feel able. It is to be ignorant to the complexities of coercion, as in the former sense and in the current Assange sense. This very clip emphasises the attitude of the British government that has developed, and the resistance and adversarial nature generated by the criticism that is leading to a genuine non-presumption of innocence. You'll understand there is no law specifying the complexities of a situation. There is no law against superficially trying to simplify it up into a nice neat bundle. There may be a law mandating the presumption of innocence, but there's no law that can accurately scrutinise media and authoritarian bodies and persons for the quality of prejudicing that presumption of innocence. This is why it isn't really necessary to incite laws at the highest level. Incite laws, should I say.
But he will have to face justice in Sweden if he chooses to do so, and it's right that he should not be able to escape justice. This is frankly a ridiculous finding by the working group, and we reject it.
This utterly, blithely dismissal does speak for personal culpability now. Personal culpability of Philip Hammond in his job and role as Secretary of State. The fact that he is able to and feels justified in so easily dismissing what is the highest body of arbitration in international law is to dismiss the concept of international law, is to undermine any future credibility for obeying international law. It is agreed, and a problem perhaps, that there is no mechanism, definitive mechanism of enforcing international law, except the goodwill of the participants who subscribe to it, and subscribe not to the laws per se, but the ideals and the principles and ideas behind it. I bring us now to what anybody who subscribes to the principles of human rights and international law are obligated to do, and that is give the case its due consideration. The Secretary of State, Mr. Hammond, rejected it for having no, for the participants were not lawyers. But on that basis, on the need to evaluate the case, how far is Mr. Hammond himself from being rationally able to assess it, if he cannot tend to the points that are raised in the case? Forget the large section contained in this report, which are the advancements, the assertions of the source, as it says, which is Julian Assange, the defendant. Just consider in this report the certain implicit and explicit lack of respect given by Sweden and the UK to international law, to the right to asylum, and to the very principles of human rights. That would be objection number one. This is in the submissions. The report details a lot of historic events and details the interactions with different governments and judgment on the information they provided in relation to Mr. Assange's case put forward by his defence. There is also counter responses by the Assange defence to those submissions. Here I note early after the preamble that it seems the panel is taking the position that the District Court of Stockholm refused to acknowledge Mr. Assange's right to asylum, and this is detailed further in the document and in the interviews. This is contrary to their own law and is evidenced on their website, how they profess to ascribe to the ideals of human rights. This is the source emphasising quite correctly, in my opinion, and in the working group's opinion. Mr. Assange had an inalienable right to security, and to be free from the risk of persecution, inhumane treatment and physical harm. That's almost extracted directly out of the Declaration of Human Rights. We note at the end of paragraph 10, the only way for Mr. Assange to enjoy his right to asylum was to be in detention. The source, Assange argues, Assange's team, the source, highlights that there is precedence. This isn't something new within the working group on the definition of arbitrary detention that recognises where someone is forced to choose between either confinement or forfeiting a fundamental right, they're entitled to such asylum, or if they're a well-founded risk of persecution. And this is a basis that the European Court of Human Rights and the United Nations High Commissioner of Refugees, endorse this principle. This would be like the Myanmar lady who was under house arrest but free to leave as long as she left the country. The point here is that detainment includes what you might call de facto detainment. De facto detainment is detainment, it's just without the physicality of bars and chains and perhaps the actual laying hands of in arrest. Those who want to cling to such a rigid definition are demonstrating irrational intransigence to the history of detainment. In the case of abducted individuals who many years later have almost perfect freedom, and yet for years and years do not leave the captor. It is, I think I've already said, it is to be intransigent and resistance and to doggedly cling to the fixed notion that there is only one kind of detainment. The source submits, an individual cannot be compelled to renounce an inalienable right, nor can they be required to expose themselves to risk of significant harm. This is a human right and agreed upon and plainly endorsed in the Declaration of Human Rights. And the conclusion, if you accept these other forms of de facto detainment, of which there seems to be no rational reason not to, lead to the conclusion that his presence in the embassy was therefore not characterizable as volitional. Yeah, it was not a free choice, but a coerced choice to be in there. The working group here recognises that Sweden is obliged by applicable law and convention obligations to recognise the asylum granted to Mr. Assange. endorsed in law and precedents is the concept of refoulement, the idea that a chain of events can be reasonably thought to lead inextricably to his deportation to the United States, where he is under political persecution, and where the United States, that's if he makes it to the United States, for all we know he might go to Guantanamo Bay, in which the United States demonstrates its complete disregard for international norms and respect of human rights, has demonstrated in its willingness to torture. I try to skip most of the mere testament and stipulation to facts. So in paragraph 61, the working group are criticising the narrow exclusionary principles that Sweden has invoked in its response to them. I believe part of the defence is that Sweden's response misconstrues the grounds for Mr. Assange's asylum. The working group finds that the case for Assange's asylum have grown stronger over time, with continued press releases by the United States about the criminal investigation that is ongoing there. I think in the media it has been patently obvious that part of this situation is a matter for the judiciary, and yet this case has been locked in the stalemate by the UK government and Sweden, when it was fully in their power to unlock that stalemate. Now, to some extent, we can understand the sentiment of how it might arise, that you feel that it is locked in stalemate because of Mr. Assange's actions, but as spoken about previously, that would be not to give due credence to his genuine fears for persecution and eventual extradition to the USA. Thus, the recognition of a problem, a legal problem, and the sitting back of the authorities, happy to do nothing except leave him feeling indefinitely detained by his situations, is wholly unacceptable. What will be raised is the idea of proportionality. Time will bear on the issue and change the factors. In this paragraph 74, it is part of the defence and seems obvious, as I've said, that the government, the UK government, has been happy to do nothing to stop Mr. Assange's indefinite detention. in paragraph 75, the working group reject the UK's claim that it is not bound by the Caracas Convention. For though they may not be signatories of the Caracas Convention, it still has international obligations. In the 1951 Refugee Convention, and that obligation obliges them to consider these humanitarian issues. And an obligation to recognise the consequences of potential refoulement to the US. The working group notes in paragraph 76, states have, under general international law, a right and a duty in certain cases to provide diplomatic asylum on humanitarian grounds. This is both the general practice of the states, the UK, the Sweden, and general practice accepted by them as law. Harking back to the Caracas opt-out, when this argument was heard at around the time of Julian Assange's grant by the Ecuadorian embassy, Ecuadorian country, of asylum, this argument was heard, but it was not acted upon within the UK. The policy has been to respect that asylum status. It has recognised it by virtue that they have not officially demanded that he be removed and sent police to the door. There was talk of this. That is just one hypocrisy. In paragraph 76, they cite a famous example where the UK was prepared to grant diplomatic asylum to a number of Terranians, blah blah blah. And examples of hypocrisy detail examples of arbitrary behaviour. There is an irony that the inadequacies of the Swedish case and the recognition of the ease with which frivolent lawsuits and demands for extradition could be generated, that we have instituted corrective UK legislation which would mean that Assange could not be extradited as it stands today. And thus the very case which generated the corrective law, Assange, will yield no benefit. This is stated benefit from. This is stated in a later paragraph. The passage of the new legislation is an admission of previous unfairness in the system, and the very person abused by it is not getting its benefit. Surely this is wrong. Surely this makes his detention more arbitrary. This is a claim by the source, Julian Assange's defence team. The United Kingdom failed to recognise his right to asylum or to offer him passage. And the working group are agreeing with him. They've communicated and got the facts and got the arguments from the government, and find that they are putting up a face of total non-respect of international law, international norms, and the concepts in the Declaration of Human Rights. Now, this is all working group commentary and verdict, if you like. And importantly, it is to note that the whole case is considered. The whole arbitrariness of his treatment at 3 separate stages. The arbitrariness of his being held in isolation and prevented from contacting, getting legal advice from the very beginning. And this went against his right to a fair trial. In paragraph 87, the working group is essentially saying, look, you've got this judicial management problem, and you've not, in a reason that has resulted in his detention, and you've not reasonably addressed yourself to the problem. You've just sat back and allowed this extended period of time to tick by, and are happy with the situation to continue endlessly without resolve. And this is contrary to the purposes of justice. And if it's contrary to purpose, it is irrational. And if it's irrational, you are behaving arbitrarily, without a well thought out principle to guide you that can be applied universally. The working group says Mr. Assange has not been guaranteed the international norms of due process and the guarantees of fair trial during these 3 different moments. This is a judgment from the submissions by the governments about their processes and what has happened to Julian Assange. And as a result, the working group feel fully justified, and I agree, that the length of time can be considered ostensibly as one prolonged period. And as such, it breaches principles of reasonableness, necessity, and proportionality. The principle of proportionality I like. It's worth looking up on Wikipedia. It says there is no rational reason to take actions which go way beyond that which is necessary to achieve the wanted end result. And so we see in this context that 5-year detainment for the need to answer some preliminary questions in a preliminary investigation as wholly unreasonable, unnecessary and disproportionate. This is the position of the working group. There is no law which is going to help the Secretary of State in arguing against these principles that he must meet. Reiterated here in paragraph 90, at the end of paragraph 91, is about being proportional to the aim sought, reasonable and necessary again. in paragraph 92, it stresses that arbitrariness does not necessarily mean against the law. Time can, over time, make a punishment unjust because of its inappropriateness and it's being disproportionate, and that this can be a straightforward injustice through the lack of predictability of the due process that you're trapped in law. Julian Assange is trapped in a process in law without recourse to get out of it. The working group assesses quite necessarily the context and the details of this Swedish arrest warrant that seems to be the root basis of this legal stalemate, and notes that it was very much of a purpose to conducting a preliminary investigation. I would add a preliminary investigation which at one stage was considered done and finished. A preliminary investigation in order to determine whether it will lead to an indictment or not. And I'll reiterate again, the extent of this legal bind Julian Assange finds himself in is very much a question, an undermining of his right to the presumption of innocence. The very media have been arbitrary throughout this long period by continually referring to the rape allegation as if it was equatable to that which the people of our nation would understand. The Assange defence team notes that the principle of proportionality is embodied in our UK law and was set in precedent by Lord Reid of the UK Supreme Court in Bank Mellett versus Her Majesty's Treasury, when he said, there's a necessity to weigh these things, and whether the objective measure is that's taken is sufficiently important to justify the amount in which one's civil liberties are encroached. This balancing of measures' effects and the rights of persons cannot be superficially dismissed with, well, he can come out anytime he likes to. It is too ready and easily an answer which must now be called into question by this ruling, this verdict, this report. There's substantial failure to exercise due diligence in meeting all these ends within their own systems, is evidence of arbitrary treatment. Arbitrary treatment which is leading to this deadlock and his imprisonment. It notes, somewhat separately to the rule of proportionality, that Julian Assange all this time has expressed a willingness to participate and resolve this deadlock in terms of completing the preliminary examination, investigation. the UK have not, the working body, the working group here, are considering the UK's evidence that they've submitted to illustrate that they didn't take seriously the possibility of extradition, and it should have been given fuller consideration. And have found that Assange has been subject to sweeping judgments of hypothetical and irrelevant. That is, they're dismissing his concerns, dismissing the international law and respecting the judgment of another world participant who is recognising on humanitarian grounds and granting asylum. And again, it defeats the purpose and the efficiency of justice to do this. All this taken, we understand then that he is denied opportunity to provide a statement, and this stands against the rebuff that he can leave any times he likes. We understand it as a acknowledged fact that he has not been given the exculpatory evidence, and the working group in Note 2 says the duration of such detention is ipso facto incompatible with the presumption of innocence. He has now been detained so long that for many they think, oh, he must be guilty. And these states have prejudiced this state of affairs. They have robbed any potential victim in Sweden of the ability for justice by scuttling Mr. Assange's chances of a fair trial. Therefore, in modern notions of legal, the necessary presumption of innocence, he cannot stand trial. In paragraph 98, the working group notes again that the UK's domestic law has drastically changed, such that Mr. Assange extradition would not have been permitted by UK law as it is now, as the holes have been plugged now.